Namaste, viewers, and a very warm welcome to this new episode of the Indian Lawyer Legal Tips. I am Sushila Ram Varma, Chief Consultant at the firm. Today's topic is contemporary and concerns the elections. Today, we speak about the SBI electoral bonds and why the Supreme Court has held against it. Now, first things first, what are the electoral bonds that are being discussed here? The SBI electoral bonds are bonds that were created by the government in 2017. They dealt with political donations that were to be made to political parties through the SBI. So SBI opened several counters across the country in which any person could go and make a donation to a particular political party for their election fund. How does this bond system work? Answer, very simple. All one had to do was the donor had to approach the desk at the SBI which sold the bonds, deposit the amount of money that he or she wanted to donate. There was no cap on the amount that could be donated, and buy the bond in which he or she had to specify which party the funds would be transferred to. Once the bond was received by the party that was to get the political donation, that party had to ensure that it was encashed within 15 days. So the next thing that would come to anybody's mind is, how do these bonds differ from the earlier bonds? Prior to the SBI electoral bonds, the system that existed before 2017 was that anybody could make a cash contribution to a political party provided they met the cap of 20,000. In the event that the contribution was more than rupees 20,000, KYC of the donor was required, his PAN details had to be given, and as such there was complete transparency in the matter. But with the SBI electoral bonds, there was no cap, there was no requirement for KYC, and a person could donate any amount of money to any favoured political party, thereby shrouding the whole donation in mystery. Now, why was the SBI electoral bond objected to so heavily by the public? There were three reasons for this. Number one, the anonymity principle. Number two, the lack of transparency which could undermine democracy. And number three was that political parties held that this was a way of paying bribes through a banking channel to the favoured party. Viewers would obviously be interested in knowing what were the type or what was the amount of donations that were paid through this SBI electoral bonds. As per figures given on the internet, the amount that was donated was rupees 16,000 crores, out of which 12,000 crores went to the ruling party and the remaining 4,000 was distributed amongst different parties. Now, why was the SBI electoral bonds challenged in the Supreme Court? The first, there was no limit on corporate donations. Prior to 2017, a company could donate only 7.5% of its net profits and not more than that. But with the bonds came an unlimited amount of donations that could be paid to any political party that the donor wanted the money to go to. This obviously meant that if a party came into power, those particular corporates that had donated huge sums would be favoured. This was not acceptable to the public, and as such, there were demonstrations against it. Another reason as to why the matter went up to the Supreme Court was that people were concerned about the lack of transparency. Most critics were of the opinion that if such huge amounts would be donated to a political party anonymously, this would ensure that there was no fair elections. Apart from that, critics were also of the view that injecting black money into the system without any accountability would also ensure more corruption in the system. The Supreme Court was concerned about the adverse effects of this anonymous donations and commented on it. Another very important aspect that was brought before the Supreme Court was the violation of the right to information. The Supreme Court held that Article 19(1)(a) of the Indian Constitution ensures the right to freedom of speech and expression, which not only means what one can say or speak, but also encompasses the right to seek, receive, and impart information on matters of public interest. So the court was of the view that this anonymity was against the right to information of its citizens. Critics had also criticized that if a party gets huge donations from a certain corporate or a certain sector of corporates, there would be bound to be favors given to such corporates, and this would go against the general interest. Further, critics also felt that legalizing black money being injected into the system was not something that would be acceptable to all. The writ petitions or the public interest litigations that were filed at the Supreme Court were titled as Association for Democratic Reforms and Another versus Union of India and Others, 2024, a matter that was decided by the Constitutional Bench of 5 judges, which included the Chief Justice of India, Justice Chandrachud. The Supreme Court was of the view that facilitating unlimited anonymous donations would actually not allow the citizen to make an informed decision before he or she decided to vote. Further, the court was of the opinion that these electoral bonds were actually hitting the right of information of the citizens, as they did not disclose what is the amount of donations that were made, and this in turn would actually affect the sovereignty, integrity, security, and the public order. The court also felt that upholding such anonymous bonds would hit the fair principles of democracy and as such should not be allowed. Now, coming to a very important aspect that was dealt with by the Supreme Court, that is the black money. The court felt that the purported objective of the SBI electoral bonds was to ensure a reduction in the black money. But the court felt that this was not correct because the fact that the entire purchase of the bonds was anonymous did not actually help in reducing the black money. To the contrary, it ensured that illicit cash or black money was brought into the system through the banking channels. And as such, the Supreme Court rejected the contention that was given for supporting the SBI electoral bonds. The Supreme Court's decision of 11th March 2024 has invalidated the SBI electoral bonds. What the Supreme Court has directed is that all state banks which were dealing in the electoral bonds must disclose all details of the donors and the amounts to the Election Commission within 4 weeks of the passing of the order. And what is most important is that the Supreme Court has reinstated the 2017 system of political donations, which were transparent and where donations beyond rupees 20,000 had a mandatory requirement of divulging KYC. If you have found this video useful, please like, share and subscribe so that we may make many more such videos. We have already written about the Supreme Court judgment on our blog. The link is mentioned below. Thank you for watching this video, and we shall meet again next week with a new topic.